In the name of Allah, the most gracious, the most merciful. Second episode. Peace be upon you. Muhammad al-Marzuki Advocates and Consultancy. We are always happy to meet you. We have talked in the previous episode about the definition of the medical liability. And in today's episode, we're going to talk about when does a medical liability arise? What are its aspects? The Emirati legislator talked about the medical mistakes, which is the reason for the medical liability, as the mistake because of ignorance with technical affairs. Whoever practices the profession should be aware of it, or mistake by deficiency, or not given the required care. The Supreme Federal Court and the Court of Appeal in Abu Dhabi defined it as a violation through defining the professional duty, which upon its violation the fault realizes. According to doctor's adherence, which is to give the required care, what an alerted doctor provides as one of the best knowledge and awareness among his colleagues and surrounding conditions during doing his work, caring for the customs of the profession and scientific rules. His deviation from this duty, its effect, his liability for its damages, affects the patient. Actually, this definition is general to include all the professional fault types, which can be enlisted under any of these descriptions, which may be resulted by ignorance as known for the professionals or deficiency. There are other aspects for the medical fault, stated by the legislator. When the doctor has been restricted by imposed professional liabilities and has been prevented from doing some actions resulting in the medical liability at his side. These liabilities are numerous, as stated by the legislator. We mention the following as instances. 1. Liability towards the rules, systems, and procedures of the profession according to the doctorate degree in the field of his specialization. 2. Regarding the health state of the patient and his personal and family history before starting to examine and cure. 3. Describing the medication and determining its quantity and way of using in writing and clearly with stating the medication name, the signature and the history in the medical description, and alarming the patient or his relatives as per the case to restrict by the way of treatment and the importance and expected side effects for the medical or surgical remedy. 4. Informing the patient with the nature of his illness and its risk degree unless his interest requires otherwise or his physical condition does not allow to be informed, and his relatives must be informed in the two following cases. A. If the patient doesn't have the capacity or if he lacks capacity. B. If the patient's health condition does not allow him to be informed personally and cannot acquire his approval to inform his relatives. 5. Observing the complication resulting from the medical or surgical treatment and treating them at the nearest time. 6. Cooperating with other doctors who are in charge of treating the patient and providing the information about his health condition and the way followed in his treatment when required, and consulting a specialist doctor if the case requires. Accordingly, any violation of any of the previous liabilities results in questioning the doctor as per affected damage. We'll leave these instances of the doctor restriction for the next episode. Our permanent motto: no give up, no loss. We have finished our episode with this end, and in the next meeting we will determine the size of this liability in more details. Kindly do not hesitate in communicating with us, and we promise you to be the best representative for you. The legal consultant, Muhammad al-Marzuki Advocates and Consultancy, Abu Dhabi, United Arab Emirates. You can contact us and communicate with us on the links under the video. Thank you.